Hello, everyone. How's it going? This is Immigration Attorney Mamita. I'm coming to you live from New York to talk to you about immigration and to see the questions that you may have on your mind tonight. But first, I do have a very special announcement to make for all of you. For all of my people who are watching me from Phoenix, Arizona, I am really excited to let you guys know that I am going to be personally in Phoenix, Arizona on March 21st. That is next week. In pretty much 7 days, I'll be in Phoenix, Arizona, and I am hosting a live event to meet as many of you in person that I can, because it is so important. I know a lot of people out here are afraid that I am not a real person or that my law firm does not exist. And so I am coming live to you. I'll be traveling all over the country this year, and I will be showing you that I am real. You will be able to meet many people from my team who'll be traveling, and I want to give you consultations. I will be doing two things during this event next week in Phoenix, Arizona at the Hyatt Regency Hotel, Phoenix. First, I will be doing free consultations between the hours of 1 p.m. to 2:30 p.m. So it's first come, first serve. I obviously will not be able to speak to everybody, but for those who are there, who are ready, who are there on a first come, first serve basis, you will get the opportunity to talk to me about your case, and I'll see what we can do for you. And second, we will be having a live audience question and answer session. So if you enjoy hearing me talk live, we will be doing a live as well in Phoenix, Arizona at 3 p.m. Don't worry if you're not in Phoenix or you can't make it. I'm still going to broadcast it here on TikTok, Instagram, Facebook, and YouTube. But for those of you who are in Phoenix, Arizona, I really hope we get the chance to meet you. For those of you who've spoken to persons on my team, for those of you who've spoken to Chantel, to Fatima, we will be there together, okay? So come meet us. The link is in the bio. If you want to come, please RSVP, fill out the form so that we can plan appropriately. We know how many people are going to come. That will really help us go, it'll go a long way in helping us make a great event for you, okay? And I will do my best to come to as many cities throughout the country that I can this year. If you are in a particular state and city, please drop it in, drop it in the comments, and we'll write it down, and we'll make a list of the most popular states. Anita, what you missed is that I am going to be in Phoenix, Arizona on March 21st, next week. It is next Thursday, for a special in-person live event. And I'm really excited. I'm really looking forward to talking to people, to meeting you, and to just getting to know people. And you don't have to sign up for a case. There's no charge. But it is only until, starting at 1 to 2:30, free consultations with me. And then I'll do a live question and answer. So even if I can't do a consultation on your case because the time has finished, I will still do my best to answer questions live in front of everybody, okay? So that's it. Make sure you RSVP if you think you can attend. There's no cost. If you think you can attend, please check the link on my Instagram bio or on my Facebook page for the RSVP link, or send us a message on Instagram, and we will send you a link to the RSVP. All right, guys, that's and if you have any other questions, let's see what people are saying over here. People are saying for me to come to DC, to Utah. Let's see, Tennessee, Charlotte, North Carolina, California. For sure, I'm going to be in California. For sure, I'll be in San Diego in July. But I love these other places. Where else? Utah. Okay, let's block the nasty people here. All right, let's see. What else? All right, let's see. And where else can I go? I'm just looking to see. And somebody's asking, what is the live going to be about, from Naveen? Naveen, well, this live, I'm going to go ahead and answer some immigration questions in a second, but the live that I'll do in Arizona in person is going to be the same thing. If you have a question about immigration in general or about your case, you can ask it live if you're there, and I'll still be answering some questions live. Ian Solano, hopefully I can meet you soon, Ian. All right, and Houston. Oh, Houston. Yeah, that's a good one. I haven't even thought about coming to Houston, but if you don't know, I lived for a few years in Texas, Sacramento. We got two people we have a lot of Houston requests. Okay, all right, guys. So just write it down in your calendar, make note of it, put it in your phone. Please don't forget. Next Thursday in Phoenix, Arizona, I'll be there. Okay. All right. Let's go ahead and answer some questions. I have a question from Toya, who's asking, signs VAWA is going in the right direction to approval from Toya. Toya, that is a really good question. How do you know if your VAWA case is going in the right direction? Because it's a long time to wait, right? The whole VAWA case, the I-360 part of your VAWA case can take between 2.5 to 3 years to process. And then after that, it could take even a little bit longer to get your green card. So how can you know that your case is going in the right direction after you have put it off in the mail? You basically sent it off into the immigration void waiting for a decision. How do you know? And the answer is that this is my honest to God answer. The best peace of mind that you will have to know that your case is going in the right direction is by first starting with an immigration lawyer who knows what they're doing, who has proven results, and who understands your case and the law. I'm not going to say that it should be me because I do think it should be me. However, everyone should, no matter which lawyer you work with, you should work with a lawyer who is knowledgeable about these things, okay? And when you work with a lawyer who is knowledgeable, who has the experience to back up that, whatever they're saying, they are going to be knowing how to work with your case, how to prepare the best possible case for you. And when you send that off, then honestly, that's how you start your case, by going in the right direction. But forget about the lawyer, right? How do you know it's going in the right direction? Because you're not going to hear anything from immigration. And the truth about this, Toya, is that you're not going to know until you know. And, sometimes you may get a request for evidence in your case. A request for evidence is basically immigration's way of telling you that they don't think that you have enough evidence, or that you're not showing the proper eligibility for your case with what you submitted, right? And when you file a VAWA case, you won't, sorry, I have like a mark on my face. You won't get an RFE until maybe 2 years down the road on your case. So up until this time, you're going to have 2 years of possibly feeling really stressed out, wondering what's happening in your case. So what does it mean to even get an RFE? And I do want to let you guys know that a request for evidence is not the end of the world. A request for evidence is simply another chance for you to make even more of an argument in your case. And why do we get requests for evidence in the first place? Well, sometimes it's because when you file your case without enough proof or not explaining things well, then you might get a request for evidence. But believe it or not, sometimes you can get a request for evidence if you give too much evidence. And sometimes we have clients who will give us 400 or 500 pages of documents and ask us to send everything. And I say, please let us do our job and let us edit this down and submit only 100 to 150 pages worth of things that are good in your case. Because if you give immigration too much, then sometimes they don't want to look at it. And sometimes they just, sometimes they can get a little bit, a little bit lazy, or, they're rushed. So they don't want to read it, and they might issue you a request for evidence instead. Okay. And thirdly, sometimes you might get a request for evidence because the immigration officer doesn't agree that you're eligible, or they don't understand the evidence that you have submitted and how it shows that you are eligible. But here's the good news. I mean, at least in our office, we don't get a lot of requests for evidence, but when we do get a request for evidence, we have one every single one. Maybe one where the client turns out that they did not have a proper divorce, but that's it. Right? Requests for evidence are not a death bell for your case. Sometimes though, if you do get a request for evidence, it's going to make you freak out and it's going to make you panic. And that's okay, as long as you are working with somebody who knows how to aggressively and assertively respond to a request for evidence. But sometimes you don't get a request for evidence at all. And all you can really do in a VAWA case is to just wait for a decision at the end of the road, which is going to take about 2.5 years. But I really mean it. The best way for you to start your immigration journey when you're filing a VAWA case or with any other immigration journey is to just start working with an immigration lawyer who has the experience and the knowledge to get your case done. Okay. Okay. Larsel's asking, please talk about some experiences of your case that have permanent bar and adjustments of status through VAWA. From Larsel. Larsel, that's a great question. Can you still get adjustment of status if you're filing for permanent for VAWA, but you have the permanent bar? Now, first of all, what is the permanent bar? The permanent bar is a very severe sort of immigration penalty for persons who have crossed one too many times into the United States. But if you want to understand the full history of the permanent bar was a punishment that was created by Congress in 1996, and it came into effect in 1997. And essentially, if you have been in the US for more than 1 year after April 1st, 1996, after 1997, if you were in the US for 1 full year, in total, even if it's different trips, after April 1st, 1997, without permission, and then you leave the US and then you try to come back without permission into the US, then you have something called the permanent bar. Or if you have any sort of deportation after April 1st, 1997, and then you try to come back without permission into the US, then you can also have the permanent bar. So what can you do if you are wanting to file for a VAWA, but you have the permanent bar? Well, believe it or not, you may still be able to get your green card through VAWA if you have the permanent bar, if you can show to immigration that that your exit from the US or the reason why you had to come back to the US was connected to the abuse that you were going through in your relationship with your child or with your spouse. And if you can show this, you would file your application with a couple of different types of additional applications, chiefly the I-601 and the I-212 sometimes, and then it gets processed. Now, sometimes you can get an interview on this, or sometimes, we're seeing our cases actually get approved for the most part without an interview. So they may even waive your interview. We just had 2 permanent bar cases approved without an interview. So our clients with the permanent bar now have a green card that they got through VAWA. And they were in the US for more than 20 years each. Okay, so let's see what else I have. Florida, DC. I'm going to come to as many places as I can. Los Angeles. I have a love-hate relationship with Los Angeles, but I'll be there. Do you come to Pennsylvania? I will come to Pennsylvania. Okay. Give me time and I will make all the plans and I will see you all. When do you come to New York? I'm in New York all the time. JSG, you're from Phoenix. I hope to see you there. Make sure you RSVP. Massachusetts, Virginia. Oh my God. I have a lot of places I have to come to. And Florida. Okay. Let's see what I'm being asked. From Raghav, how long will it take to get a green card after the VAWA gets approved? From Raghav, Raghav, we are seeing our clients get a green card within approximately 6 months after the VAWA is approved, or get called in for an interview within 6 months after the VAWA approval as well. Leslie is asking, what evidence can I give if me and my now husband were in a long distance relationship? Leslie, I'm just scrolling up to see if you have any more to that question. So Leslie's question on TikTok is about how can she show that she and her husband were in a relationship if they were in a long distance relationship. Okay, Leslie, so let's talk about this. If you are filing the regular marriage case where your husband is petitioning for you and you're doing the I-485 and an I-130, can you still get a green card even if you don't live together in the same place with your spouse? And the answer is that it depends, because a lot of times the When you are doing a joint marriage green card case, if you and your spouse don't live together, then it could be they might consider it to be a fraudulent marriage, and they're going to give your case a little bit of a harder time. However, there are lots of cases that I've gotten approved where the clients do not live in the same state, but usually you should show like a good reason why you don't live together. Like, for example, maybe it's because of work, maybe it's because of college, or someone's in the military. So if you are not able to live together, you can still show that you're sending each other money transfers, or you share a bank account still, or you travel to see each other. Maybe there's some other assets that you have together, such as insurance policies and things like that. But yes, it is true that showing evidence of your relationship is a little bit more difficult if you don't live together and you are in a long distance relationship. But let's talk about the VAWA scenario. If you are filing for a VAWA and you are not living with your spouse, right now, when you file, that's okay. However, for a VAWA case, we do have to show that you lived with your spouse for at least any period of time. It could be 1 day, it could be 1 week, it could be 1 month. And in fact, this week we got an I-360 approval for a client who only lived with her husband for 1 day, and it got approved, okay? However, the definition of having a joint residency or a shared residency is where you really have one home to live in. If you maintain an apartment and your spouse maintains an apartment and you just kind of like visit each other, that is probably not going to work, but we can try. However, immigration wants to see one place of residence, okay? All right. I have a question from Many Blessings. Can your spouse come to America while waiting for the I-130 by his American wife for a spousal visa from Many Blessings? Many Blessings, that is a really good question. And I know that a lot of you might be in this situation where you are here, but your husband or your wife is overseas, and you're trying your best to bring them here and you're missing them, right? So if you have filed an I-130 for your spouse, can they come to the US while it's processing? And the answer is that it depends on if they already have a visa of their own to come to the US. Because just filing an I-130 actually does not entitle somebody to come to the US. That's why your spouse has to wait for the spouse visa to be granted first at the consulate. So a couple of options could be that if your spouse already has sorry, this is a little bit out of focus. I'm trying to focus my camera. Sorry, it's not really working. But if your spouse is waiting for their I-130, then they might be able to come to the US if they already have a visa to visit, right? However, what if they don't have a visit visa and they want to apply for a visit visa to come to the US? Can they do that? And the answer is yes. Well, anyone can apply for a visit visa to come to the US, but will anyone get it granted? Will everyone get it granted? And the answer is no, because when the consular officer sees that you may, you have a spouse in the US, or that you might be at risk of overstaying in the US, then they're actually less likely to grant you a visa to visit the US, because they know that you might stay, right? But it's always worth a try. Many blessings. It doesn't hurt, right? Let's see what questions I have. I don't have my ex-husband's birth certificate. Can I file for a VAWA from Clumsy Girl? Clumsy Girl, yes, you can. So one of the things that we do have to prove in a VAWA case is that, if you are filing for VAWA as a spouse of a US citizen or a green card holder, you have to submit evidence in your case that your spouse is a US citizen or a green card holder. So you can either show a passport or a birth certificate, but many times you may not have access to this information. So what are your options? Well, number one, as long as you know your spouse's full name and date of birth, we can do some searches. We can look online. Sometimes we can look up military records, voter registration records, things like that. If you have their driver's license, that's always also really good too. And when we don't have the actual physical proof of citizenship, then what we do in our cases and what you are allowed to do is you are allowed to write to USCIS in your case that I don't have this. Please take any of this information that I can find, including name, birth certificate, birth date, social security number, driver's license number. Please take these pieces of information and verify that my spouse is a US citizen on your own. So actually, in these cases, we can actually put the burden a little bit on USCIS to verify that status, okay? So clumsy girl, even if you don't have your husband's birth certificate, don't worry, please call us if you need help, okay? Also, our phone number is 212-248-7907 for those of you who would like to schedule an appointment with us. Harsh is asking, once you have your 2-year conditional green card, your marriage is broken, and your wife cheated on you, once your green card expires, do you need to apply for travel documents? And Luis, hope to see you in Phoenix too. Gabby, I will come to Texas soon, okay? Just to see you too. Okay, so when you have a conditional 2-year residency card and your spouse cheats on you, your marriage becomes broken. You know, I don't like to use that term, but if somebody is using it, if your spouse is cheating on you and your marriage has become miserable, what are your options? And the option that you're going to have, there are probably 2 options that you may have. Number 1, if you actually get legally divorced in your marriage, then you can file for your 10-year card, your I-751 application with a waiver requested underneath the divorce section. However, if you have not yet gotten divorced, or if you don't have a lot of evidence to prove your marriage, then my recommendation would be to look into doing the extreme cruelty and battery waiver, because in these cases, when you don't have the divorce yet, your spouse won't give you the divorce, or you don't have, you barely have any marriage evidence, or you have very little marriage evidence, the extreme cruelty and battery waiver really helps to explain a lot of this. And you can file both of these things without your spouse, obviously, because it is going to waive that joint filing requirement. So when you file your I-751, that's all that you have to file, and you will get a receipt that says that you will have an extension of your legal status for 4 more years. So when you file your I-751, you will get a paper letter that will tell you that your conditional residency is extended by a period of 4 years. And with this letter and your expired green card, you can actually travel internationally. You can show this as proof, and you're still considered a green card holder. And I do want to let you guys know that you can file your I-751 even if your card already expired, okay? So don't sit there for years because thinking that you can't do anything because your card expired 3 years ago. We literally got an I-751 approved for one of our clients whose green card expired 10 years ago, okay? And we filed an I-751 waiver underneath the extreme cruelty and battery exception, okay? All right, guys, this is all the time that I have for today. Again, don't forget, I'm gonna be in Arizona in next week, next Thursday, March 21st, Thursday, okay? Make sure to RSVP. I really, really hope to see you guys there, okay? Have a wonderful night. Take care.